Caribbean, joined by water, connected by culture, and linked by a common heritage.
Welcome back to all our viewers. We went to a break looking at the impact of the commercial division on business, especially in the BVI. Anne, who is our guest from Antigua, she was explaining the importance of this, and we just want to hear a little bit more from her on the impact of the commercial division of the court on business in these various jurisdictions that it serves. Anne?
Yeah, I think if you look at a court more as a dispute resolution medium, it then facilitates the mindset that you wish to have a different division which can be very focused on expeditiously and properly and appropriately resolving disputes which involve international players. If you look at some of the judgments coming out of the commercial court in the BVI, you will quickly realize that a lot of the commercial matters that are dealt with by that court, in fact, barely touch the jurisdiction of the BVI. The companies that are involved have presences outside of the region, sometimes in Europe and sometimes further afield. The BVI is the domicile of the company, and I'm not going to tread on Renee's area. I know that she's very strong on IBC, so I'm sure she can elaborate on that. But in terms of the dispute resolution aspect of it, the BVI must present that as being the platform in order to secure its place and its preeminence in the IBC world. So it is that for that reason that it is important to have, to my mind, to have a commercial division of the court. That doesn't say that they only deal with IBC cases. Once it is a commercial transaction, then it can be dealt with, or it would be filtered into the commercial court system. Now, the point that Ruggles had made earlier about the CCJ and its original jurisdiction is an important one in the sense that if the dispute, in fact, concerns a matter which falls under the Treaty of Chaguaramas, then it will automatically have to be referred to the Caribbean Court of Justice for that determination to be made before the court in the Eastern Caribbean, whether it is the commercial division or the civil division, would continue to resolve the issue otherwise. So that is where the two courts would come into contact with each other if it is a matter that falls under the Treaty of Chaguaramas. If it does not fall under the Treaty of Chaguaramas, it would be dealt with by the Eastern Caribbean Supreme Court in the normal way. In Antigua, for example, we can file matters in the commercial court, but why would we do so when, in fact, the commercial court is situated in the BVI? When we can file commercial matters in the High Court in Antigua, and unless we specifically require them to be dealt with, or it is deemed to be appropriate for them to be dealt with by the commercial court in Tortola, then it will be dealt with in Antigua in the normal course of civil litigation. Okay. There will come a time sometime in the future, maybe in the next, 20 years or so, where there will be a commercial division in each of the jurisdictions. Really? But for the time being, the greatest bulk and volume of work which engages the commercial court is in fact coming out of the BVI and to a lesser extent out of Angola.
But we had just touched on the growth of the court in terms of the number of judges. The 20 judges you mentioned, Ruggles.
Over 20.
Over 20. That's at the High Court level or at the appeal?
No, High Court.
Or just the High Court?
Yes, there are 5 judges, 5 full-time judges at the appellate court. It started off as 3. Now we have 5 judges at the appellate court, and we have 5 masters. The masters are responsible for what is referred to as case management of matters. And in fact, that is an important development that has taken place in the life of the Eastern Caribbean Court. One of the significant features of the court is the introduction of new civil procedure rules to govern civil matters in the court. That was done in 2000, before we operated under 1970, what is referred to as old rules. So for the past 17 years, we have been operating under new rules. And the Eastern Caribbean Court has, in a sense, been a trailblazer for new rules in the Caribbean. You have it in Jamaica, in Trinidad. Barbados is just about getting into it. But we have had these rules since 2000. And one of the features of the rules is what you call case management. It has moved from a lawyer-driven system under the 1970 rules to a court-driven system. So, for example, before 2000, if a lawyer did not make an application to have the matter moving, the matter is stuck in the court, everybody has forgotten about it, and a lawyer did not make an application to have that matter moving, it stayed in the system. Now the court, once you file a matter in the court is responsible for that matter. And it's the court, it has a stage called case management. And that is where after you file, like the claim is filed and the defenses are filed, the reply to the defenses, a stage called the pleading stage. It goes to case management. And at that stage, the court now will identify the important activities to be done with that matter up to the stage before trial, called pre-trial review, and set deadlines for it. So actually, most of the work now under the new rules, that work is done up front. And the whole aim under the new rules is to avoid ambush. So by the time you reach trial, both parties would know how many witnesses each side is calling.
Yeah, they'd know everything about the case.
Each witness is coming to say,
right,
because you have witness statement filed, and what documents each party is relying on. That is a radical change from pre-2000 and a significant development.
That is something,
in the
Ruggles,
court.
I want each of you to speak to. The matter of the length of time it takes. And we know time in legal time is different from time in regular time. It's like we have island time and other time. We have legal time and we have other time. We look at this case in Grenada recently, the Oscar Bartholomew case. And it took the court more than 5 years to determine that an action that was taken by the DPP was correct. More than 5 years. And although you were speaking specifically to civil matters, it applies, I know, to criminal matters as well. We talk about the growth of the court, the fact that there is more staff, there is now e-systems that are being used, but we don't see any faster movement as far as justice is concerned.
Well, let me make a distinction immediately. Well, in fact, as you made, the Oscar Bartholomew matter falls under the criminal law. And all these rules I speak of, the new civil procedure rules, they govern civil matters. So actually the move is to have case management in criminal matters. In fact, the move now, there's a pilot project in St. Lucia undertaken by the criminal division in the court, for example, to wipe out preliminary inquiries, to abolish preliminary inquiries, to do what is called paper committals at that level. So you cut off a whole stage of PI when you deal with serious matters like murder, manslaughter, rape, and these matters. So you don't have case management at the criminal level. However, with the Oscar Bartholomew case, it started, the preliminary inquiry actually started. It was challenged on the basis that the charges ought not to have been laid given the circumstances allegedly under which death occurred, and what ought to have taken place was a coroner's inquest. The inquest started, the matter went on appeal.
But it took 5 years to determine that the action the DPP took was correct. 5 years.
Well, at the level of appeal court, and personally I would agree with you, that is a long, it's a long time. It's a long time, but it is not unique for Grenada or the Eastern Caribbean, where you have many of these matters extending for long periods of time. But I agree with you. I agree with you that most of these matters ought to be dealt with more expeditiously. But there is no case management formally at the criminal level. And remember, our system is an adversarial system. That case involves about 5 accused, several lawyers, several technical arguments raised back and forth. So you find these things happening right now. There's a case going on in the Turks and Caicos Islands, probably a criminal matter, and it's entering its 2nd year. There are 100 and something witnesses. It has gone up and down the Privy Council and back, but that's the nature of the justice system at times. It grinds slowly.
We're going to come back to that in a little bit, but we want to continue looking at the evolution of the court over the 50 years. And one of the areas that I want to touch on is the administration and the operations of the court. Anne mentioned it, she touched on it briefly a while ago, and she talked about various different parties in different jurisdictions meeting virtually to hear the case. I want to find out from all of you, and especially from Renee, who is now president of a bar association. Ruggles has served.
Instead of the continuation of the adversarial matter, we can look at issues, narrow them down before a person who is a trained court mediator. And that has done, starting to impact in St. Vincent quite a lot. And I understand Grenada has particular good success rate in relation to the introduction of court-ordered mediation. So that speeds up the process and also gives a chance for the claimants and the defendants to be sitting across the table and speaking the terms how they understand the issues with a court mediator.
There is no denying the impact that mediation has made in the court, no denying it. But at the end of the day, we still have a long queue. There is still.
I'm sorry, you still have a long one?
We still have a long queue. There are still many cases waiting over many years to be settled. Not just to be heard, but to come to a conclusion.
Yes, but what I would say, this is a continuing work in progress. It's not a destination. It's a continuing work in progress where you try to become more efficient, more effective, and with the introduction of the new rules in 2000, I think it's undeniable that matters have gone through the court system certainly more efficiently, more effectively, more quickly. You have had disposal of matters up to the level of trial than pre-2000. In fact, the statistics show that before 2000, you have an average of 10 years a case is taken to go through the system. And you know what? On the day of the trial, the case is settled. About 10% of the matters filed went through trial under the old system. Under this new system, we have had, and I'm speaking relatively speaking, relative to the old system, and I'm not saying here that there is no need for significant progress, but when you look at the trajectory, it is the improvements are it's becoming more and more efficient. And mediation, remember, mediation is now officially part of the court system. It's not just a side thing now. So under the old system, for example, people sat back, the matter is coming up for trial, and suddenly on trial day, somebody introduced some new document. Somebody, they bring witnesses, and then people object. You hear technical arguments. You have not gone even into the substance of the case. Under the new rules, all of these preliminary matters are dealt with upfront at case management at a stage called pretrial review. So when a matter is set for trial now, on trial day, you go in, you call your first witness in the box, and that trial takes place invariably over 90% of the time. By the time that matter goes to trial, most people would have explored mediation, and it may have failed at mediation. And Renee mentioned earlier, Grenada has a proud record of mediation over the past 13 years. Mediation was introduced in the court in 2004 in the Eastern Caribbean Supreme Court. In fact, I think the two most significant developments in terms of access to justice has been the introduction of the new rules in 2000 and mediation in 2004. Actually, the new rules provide for alternative dispute resolution, including mediation. And what mediation does, it allows the parties to resolve a matter. And with that resolution, it's not a side thing. It becomes an order of the court. That agreement becomes an order of the court and enforceable. And in Grenada, we have settled close to 1,000 matters, if not over 1,000 matters through the mediation process. We have had a 2/3 success rate in mediation.
And Renee, you had mentioned that it's taking root in St. Vincent as well. What has been the success rate like there?
We are also still a work in progress. What I can tell you, what has actually happened, we used to have one judge doing criminal and civil matters. So you had the criminal assizes in February, June, and October. And they had this long volume of work that they still had to do the civil work. And the requests were made over the period of time for more judges. And now, in fact, we have one judge that sits throughout the year doing nothing but criminal work from January to December, and two judges operating under the civil calendar, so that they are going simultaneously, side by side, and also a master who is resident. So that has speeded up the process of the caseloads. And also we have been able to deal with a significant number of the cases that were hanging there for 10, 12 years. The mediation is growing. We have to do more public education on the value of mediation, and also for the parties, for the general public to understand that the mediation is not, as Ruggles said, a side thing. It is also part of the process of the court, part of the work of the High Court, and it is also assisting with access to justice and ensuring that the justice is done in the matter, so that the parties can understand it's the same as if you went in and stood in a witness box and was sworn in, because you have to be also given testimony that is true and correct. So that we try to lessen the adversarial aspects of the civil matters and get them moving along. Because sometimes, as Ruggles says, for years you're going on with this, and you turn up at court in the morning and the parties decide either to drop the case or to come to an agreement, and you could have done that much earlier in the process. Now that is provided for under the court rules.
No, we are going to run out of time very quickly on this show, and I have a number of issues that I want to raise with you all. One of the things I wanted to look at when we touched on funding, we kind of segued into the looking at how justice is linked to that. But one of the main issues I wanted to bring up when it comes to funding, Ruggles, is the matter of the state of the physical plant that the judges and all the court officers have to work in. They're in a deplorable state. No way of saying that nicely. The courts look bad, the registries look worse. What is happening? We've heard, Chief Justice Pereira at the opening of the law year last year, I remember she spoke to this issue, and she says for the past 10 years it's being discussed, the halls of justice.
Right. Yes. Well, there is definite need for improvement in the physical facilities of the court. But don't make it sound that bad.
It is that bad.
It is worse.
There has been
Thank you, Rennie.
in some of the islands. I think St. Vincent, where Renee is based, they need some significant injection in terms of physical facilities. However, if you go to Antigua,
undeniable.
Antigua has probably in the OECS, Antigua has the best facilities. Antigua has close to what is we would view as a halls of justice. And in Grenada, in recent times, under the Juris Project, we have been able to actually have 2 additional courtrooms in the Cable and Wireless building. So there has been improvement, but there is need for significant improvement in several of the islands. And the ideal is the Halls of Justice program, where in each jurisdiction, in each of the 9 islands of the OECS, and as you say, that has been spoken about for ages,
for a decade,
where you need the improved physical plant. The whole idea, like the Halls of Justice in Trinidad, for example, you have all the civil courts, all the criminal courts, you have the library facilities, you have the registry facilities, all in one single place with an improved plant. And the challenge with that has been funding, and it's a continuing work in progress. The bars are continuing to advocate for halls of justice in each of the 9 islands, and we hope ultimately it comes to fruition one day. Probably Flo, I think of
we're going to take a break. We're going to take a break on that note, and when we come back, we are going to continue to look at this issue, because we want to hear from Renee what the situation is in St. Vincent, and also from Anne what it's like in Antigua. I'm glad we raised these 2 extremes. We can hear from these 2 lawyers what's happening in their countries. Viewers, we'll be right back.